Welcome to the House Criminal Justice Committee for Wednesday, February the 9th. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio. Mr. Chairman, you have a quorum.
Thank you very much. Members, any personal orders before we get started? We do have a fairly full calendar in front of us today, but want to make sure if there's any personal orders. All right, seeing none, we'll get right to work. We have item number 1 on our calendar, House Bill 1646 by Vice Chairman Hall. Sir, you have a motion and a second. You are recognized.
Thank you, Mr. Chairman and colleagues. Members, historically, the assault on a law enforcement canine has been nothing more than a destruction of
Vice Chairman Hall, I apologize. I just wanted to interject here. We do have an amendment traveling with the bill, and it makes the bill. Is the only reason I wanted to stop you there.
Yes, sir, that is correct.
Okay, very good. And that one is coded 12809. We have a motion and a second. Question's been called. All those in favor of attaching amendment coded 12809 to House Bill 1646, please signify by saying aye. Those opposed, you adopt. Sir, you're recognized on your bill as amended.
Thank you, Mr. Chairman.
Yes, sir.
Members, historically, the assault on a law enforcement canine has been nothing more than a destruction of property crime. House Bill 1646 changes all of that, and it moves it to a Class B felony. It takes the shackles off of the DA, and it allows him to address the proper crime depending on the aggressiveness of the act. This bill is endorsed by the Tennessee Sheriff's Association and all 95 sheriffs. And all of the ingredients are in this bill. If you love animals, if you want to be a good steward of the taxpayers' money, and if you're pro-law enforcement, all the ingredients are in House Bill 1646. I also want to add that we had 17,000 signatures on a petition in my district that supported this bill. 250,000 positive responses on social media that supports this bill. And a wide range of support across this country. And other states have reached out and wanted to duplicate this bill in their state. With that, Mr. Chairman, I renew my motion.
Members, you've heard the explanation of the bill. I do have a question from Chairman Howell. Chairman Howell, you're recognized.
Thank you, Mr. Chairman. Representative Hall, I believe there are some guests in the audience from Bradley County that had input into this bill. With the chairman's permission, could we introduce those folks, Mr. Chairman?
Please, go
I
right ahead.
will let Representative Hall do that.
Oh.
Thank you, Mr. Chairman. We have Marcus Easley and constituents all the way from Bradley County that come to be with us today in support of this bill. Could we make them feel welcome, please?
Thank you all for being here, and always great when folks can come and watch this process, and I know this is an issue that's important, not only in your community, but obviously you all, so thank you so much for being here today. I do have Chairman Doggett on my list. Chairman Doggett, you recognized?
Thank you, Mr. Chairman, and Representative Hall. Could there possibly be with this bill if a service dog or more specifically a police dog was killed in the line of duty, could there also be an additional property crime for this? Because I know the cost of these dogs to be trained, from the time they're purchased from a breeder and then they go through the training, they could be in excess of $75,000. Could there also be an additional charge for, as a property crime as well? Could they go together is basically what I'm asking.
Vice Chairman Hall.
Thank you, Mr. Chairman. That would be a great question. That would be at the discretion of the DA. And that's why this bill is so important, is that it takes the shackles off the DA and allows him to address depending upon the aggressive nature of the crime.
Chairman Doggett.
Yes, sir. Well, thank you very much for your work on this.
Thank you, sir.
Next on my list, I have Chairman Halsey. You recognize, sir.
Thank you, Mr. Chairman, and thank you, sir. As you know, you and I agree on about 99.99% of stuff. I have some problems with this one, so I'll make all the sheriffs mad and everybody else. I just have some questions that really concern me. And first off, I I was in law enforcement for 36 years, and I understand completely and perfectly the bond that sets up between a handler and his dog. I worked with him for years. My issue has to deal with some fundamental things. Animals have always been classified as property. That's the way we always did it in the past. And by the way, I'm against enhancement of different classes of people when we pass a lot of other bills down here, and I have been guilty of it in the past, but I don't like it. But we've always dealt with animals as property. And now in this case, we're shoving from a Class E felony to a Class B felony. And that causes a lot of grief for me in several areas, and let me give you an example. To me, we should look at what it costs for a police dog, probably $15,000. But then you got hundreds and hundreds of hours of training that a police officer works with a dog. Classifying a dog as property owned by the city or the county, if somebody seriously wounded it or killed it, to me, you're very just and you stand on righteous ground when you say this is destruction of private property or destruction of city property to the tune of $35,000 or $40,000. That bumps you to a Class C felony already. Maybe more than that, depending on how expensive it costs. To me, you're still keeping this in the right lanes as property. When we assign a Class B felony to serious injury of a dog, it brings other problems to me too. If a police officer's with a dog and they're chasing a suspect, and he turns around and shoots at the dog and wounds it and shoots at the officer and hits him in the shoulder, the DA is going to charge him with this Class B felony, 8 to 12 years if he's a range 1 offender, for seriously wounding the dog, but depending on the circumstances, he could get charged with aggravated assault for wounding an officer, and that's a Class C felony. So now the dog gets a stiffer penalty for wounding the dog than shooting the officer. I have several problems with that. I just wish we would keep it in the lanes that it's always been, and that it's property, and put a value on it, and let that be what the penalty is, because you're going to get close. I don't know that you'd have a B felony, but you'll get close to it with a C, but it keeps it on the right foundation. I also was just going to say in passing, I don't understand the physical note. Class B for a range 1's 8 to 12 years, and it's got a $10,000 physical note on it. I don't understand that because it costs $29,000 a year to put somebody up in one of the 14 penitentiaries in the state. Anyway, that's my thoughts. Your bill will pass, irregardless of what I think, but those are the problems that I have.
Vice Chairman Hall, you're recognized.
Thank you, Mr. Chairman. And in the state of Tennessee, there's been cases where a 10-year sentence resulted in a 14-month prison stay. 8 to 12 years, the ambushing my law enforcement K-9 could be out in less than a year. If you want to move the needle in a positive direction, even if it's just one notch after this bill has been amended and watered down, it's still a Class B felony. If you're going to make any changes at all, regardless of how minute, Class B felony is where it needs to land.
Chairman Halsey, you're recognized.
Unless I can get my bill passed, and it's truth in sentencing, if you get 8 years and that's what the judge gets you, that's what you serve.
Thank you, Chairman Halsey. Seeing no one else on the list, we're ready to vote. All those in favor of sending House Bill 1646 as amended to Finance, please signify by saying aye. Aye. Those opposed? No. Sir, you head to Finance. If you wish to be recorded a no, please let the clerk know.
Thank you, Mr. Chairman, colleagues.
Thank you, sir.
Thank you, members.
Thank you for your work. Next, we have item number 2 on our calendar, House Bill 1766 by Chairman Howell. Sir, you have a motion and a second. You are recognized.
Thank you, Mr. Chairman. This bill came to me from the District Attorneys Association. It seeks to close a loophole in state law. This bill adds conviction of continuous sexual abuse of a child to the list of offenses that currently require a judge to revoke the defendant's bail immediately upon conviction. And some of the other items on that list are first-degree murder, aggravated kidnapping, aggravated robbery, rape, aggravated sexual battery, and this would just add continuous sexual abuse of a child to that list, Mr. Chairman.
Members, you've heard the explanation of the bill. Any questions? Seeing none, we're ready to vote. All those in favor of sending House Bill 1766 to calendar and rules, please signify by saying aye.
Aye.
Those opposed? Sir, you had to calendar and rules.
Thank you, sir.
Thank you. That brings us to item number 3, House Bill 1678 by Leader Lamberth. Leader Lamberth, you're recognized with a motion and a second.
Thank you, Mr. Chairman. And very simple bill. If you commit a robbery right now with a fake gun, it is still a robbery. This would make it clear that if you commit an aggravated assault with a fake gun, it is still an aggravated assault. Through the eyes of the victim, it doesn't matter whether it's a fake gun or a real gun. The fear that it puts into them is still the same.
Members, you've heard the explanation of the bill. Any questions? Seeing none, we're ready to vote. All those in favor of I apologize. Representative Dixie, you're recognized.
Does this just apply to fake guns, or is it any particular object in their hand? Just for clarification.
Leader Lamberth.
Great question, and I appreciate you asking it. I use gun as an example of one of the type of weapons that it could be. The language of the actual bill is use or display of a deadly weapon or any article used or fashioned to lead the victim to reasonably believe the article was a deadly weapon.
Chairman Dixie, you recognized.
The reason why I ask, I think we're all aware of what happened. We're all aware of what happened here in Davidson County about a week ago when the young man was probably in some sort of mental crisis and he had a box cutter with him, and this would fall up under that, then I'm assuming. Unfortunately, he was killed, but if they were able to talk him down from that and he would have had an additional charge, this would be an additional charge to that, or how does this work?
Leader Lamberth.
No, sir, this doesn't involve that situation at all. And I realize that's a recent situation and such a tragedy for both those officers and that individual. I've watched that entire video that's been released, and it certainly is a very difficult situation. But in that video, if you review it, that poor young man who obviously had some mental health issues, they spent about a half hour trying to talk with him and talk him out of the actual weapon, not what we're talking about here, where it could be a fake weapon that was designed to look like one. He had a real box cutter. And then unfortunately, at the very end of that video, it appeared, at least to me, and I know it's under investigation and the experts can investigate it, that he dropped in what appeared to be a shooter's stance with something else. And so this bill doesn't affect that. I will say it is a tragic loss of life and situation for, I think, everybody involved, both for his family and those officers as well, because at least from my perspective, it appeared that they tried everything they could to deviate from that end result. But this bill would not affect that situation at all. There may be many other bills that would, but this one simply doesn't involve that.
Chairman Dixie.
Thank you for the explanation. I just want some clarification, because I think we all agree that was an unfortunate situation, and we don't want that to occur. But we also don't want that someone, in the event that they can be talked down from that situation, and they're obviously in a mental health crisis, I don't want them to be subject to additional charge because they were not thinking clearly at their mind, because maybe they did have something, an object that could be considered a deadly weapon. So I just wanted just clarification on that, but thank you, and I appreciate you for the explanation.
Question's been called on the bill. All those in favor of sending House Bill 1678 to Finance, please signify by saying aye.
Aye.
Those opposed? Sir, you head to Finance. Next up, item number 4, House Bill 1679, also by Leader Lamberth. Second. Sir, you have a motion and a second. You're recognized. I also see, members, we have an untimely filed amendment. It is coded 13388.
Second.
So we have a motion and a second. This is now for us to vote on whether or not to hear the untimely filed amendment. Just want to remind everybody the posture we find ourselves in. All those in favor of hearing amendment coded 13388, please signify by saying aye.
Aye.
Those opposed? We are now on. Leader Lamberth wishes to move amendment coded 13388. I need a motion and a second on the amendment. We have a motion and a second on the amendment. Sir, you're recognized.
Thank you, Mr. Chairman and members. Thank you. We've had 2 or 3 different amendments on this to try to get this language exactly in the right posture, and there's a number of other groups that have worked on this. Representative Halford had reached out to me in between year 1 and 2 of this legislative session and had a young lady in his district who was charged with a theft, and then several years later was charged and convicted of a DUI. She was guilty of both, and under our statutes, the theft is an expungible offense. It's a first-time, low-level offense that we have for years allowed folks to be able to expunge. What came as somewhat as a surprise to me, and I probably knew this and had forgotten it at some point, but it's what you have on your record at the time you file for an expungement, not at the time that you were convicted of that offense. This fixes that, and it says, she had a theft and a DUI. The DUI, under current law, blocks her from being able to go back and get that theft expunged. And Representative Beck asked a very, very good question, as you always do, last week, as to whether or not we would allow folks to kind of cherry pick where in their criminal history they wanted to expunge something. My answer was no, our intention was not. And yet the language was a little murky. And so we tightened it up to make it clear that if that young lady were to get a DUI and then a theft, unfortunately, it would not be expungible, because you could get a lengthy history like that and just kind of pick an offense and pluck it out of the middle. If she got a theft and a DUI, as she did, this bill would say the theft is expungible. And it's expungible 5 years from the end of that theft sentence, because the other issue that is in the statute now is that you have to wait 5 years from the end of the most recent sentence. This fixes that, and it makes it crystal clear, just like we passed last year with the chairman's bill, that you get one bite at the apple. You get one time to get an expungement. But this will allow folks like that young lady to be able to go back and get it expunged. Why it was important in Chairman Halford's constituent situation is that that theft was keeping her from being able to be employed where she wished to be hired. The DUI was not, but the theft, the nature of that offense was simply something that they said, hey, we can't hire you if you have a theft on your record. In her case, that was literally the only 2 instances on her criminal history. So that's what this bill does, and that is exactly what the amendment does.
Members, you've heard the explanation. I do have a list. Representative Griffey, you're recognized.
Thank you, Mr. Chairman, and thank you, Leader Lambert, for bringing this bill, and I'll probably vote for it. But I just wanted to throw out an idea for this committee and the members of the General Assembly to perhaps consider, particularly if we go along with truth in sentencing at some point. It seems to me that the whole purpose of expungement was to try to create an ability of someone who'd made a mistake and gotten a conviction, not to have that held against them forever, particularly if they turn their life around and comply with the law and stuff, for purpose of getting employment. And if that's the intent of it, and I think that's a proper and a good intent, particularly for folks that are well deserving. What has kind of caused me some concern with the expungement is that once a conviction is expunged, I mean, that conviction's gone for all practical purposes. So what if an individual got a conviction expunged, but then later on commits another offense and could be serious and so forth? Should that individual, should they still be entitled to have their convictions hidden or for future purposes? But so I would offer as a possible solution that persons who having a conviction on their record could apply to a circuit court judge, even general sessions judge for maybe misdemeanors, and just apply for sealing their conviction history from prospective employers and people that want to inquire on criminal history, and those records could be sealed. And then later on, if someone should commit another offense or something, or that history would still apply and carry with that person, because I think people need to be responsible for their actions, and there ought to be consequences for decisions. So I just want to throw that out there. Maybe that's something for a future discussion or whatever, but, I will be supporting your bill, Leader. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Griffey. Next on my list, I have Chairman Dixie. You're recognized.
Again, I don't know, I know 2 for 2. I don't know what's going on here today, but I'm supporting your bill. But I just had a quick thing. I think
Welcome,
this was just
sir. Welcome.
this was a appropriate time to ask, or maybe like just for consideration. And you made a point. You said that you get one bite at the apple at this. And I was just thinking about, I've had some constituents and friends that maybe have gotten to trouble 20 years ago, 25 years ago, never been in trouble since then. But sometimes we know that when they're going through this particular downward spiral, they catch 1, 2, 3, 4 cases before they finally wake up and say, you know what, this is what I was not meant to do. This is not what life's about. Maybe would it be future consideration for people who have not been in trouble for that long to be able to come back and get that maybe other 2? Because if I'm not mistaken, you can get 2 offenses with 1 expunction, correct? And then maybe they could come back and do other ones. Will there be consideration for that?
Leader Lamberth.
Thank you, Mr. Chairman. And there's, I think, always consideration into both gentlemen's point. I mean, we've talked about sealing records for a while. This bill, the caption would really not hold that. But I think it's a conversation to have. I will say, when you're talking about multiple offenses, expungement really is based on the Old Testament principle of forgiveness of sin, where it is wiped clean as if it never occurred. Sealing a record allows it to still be there for purposes of law enforcement, to Representative Griffey's point, and for enhancement if you were to commit a crime later or something of that nature, but employers and the public could not see it. So it is a conversation that seems to have been percolating for some years. It wouldn't necessarily fit on this bill, but is something worthy of discussion.
Thank you, sir. All right, members, we're ready to vote. All those in favor of adopting Amendment Coded 13388 to House Bill 1679, please signify by saying aye. Aye. Those opposed, you adopt. We're now on the bill as amended. Leader Lamberth, you're recognized.
So, Mr. Chairman, 2 things. One, I did want to indicate, since I have another bill that has a fiscal note that is a little hefty, this one increases local revenue by almost $1 million. So all of you can get a thank you note from your local jurisdictions for that additional funds if we were to be successful here. I also want to say that, members, I did not intend to file a late amendment. I know there are some groups that have not seen this amendment. I'm at the will of the body as to whether or not to go forward today, whether or not to roll this a week. And Mr. Chairman, whatever your guidance to me or the committee's guidance would be, I'm comfortable either way. I mean, it is in the posture that we intended it to be in, but it was a late file amendment, and for that I apologize.
Well, unless there is any objection to voting, which I do not see any, then we are ready to vote. All those in favor of sending House Bill 1679 as amended to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance. But I will say, Leader Lambert, thank you for making that offer, but I think we're good.
Mr. Chairman, I try to do it the way you want us to, and I don't want to mess up anything in your committee.
Excellent. Members, that brings us to item number 5, House Bill 1763, again by Leader Lamberth. Second. Sir, you have a motion and a second. You're recognized.
And Mr. Chairman, I believe you have an amendment to this one. I just assumed you liked it so much you wanted to make it even better.
Absolutely. If you don't, with your indulgence, I'm going to move Amendment Coded 13293.
Second.
Thank you for that. I don't know, can I gavel my own amendment?
Sure.
Members, what this amendment does, it keeps intact the leader's intent here. What we're dealing with is pill presses. And a number of years ago when I was touring the TBI, I was educated that not only do drug dealers and other ne'er-do-wells have these pill presses at their disposal, but oftentimes there will be a gang of folks or a ring of folks, and they will have pieces of a pill press. They'll come together in a storage unit on a Saturday night with their fentanyl. They'll make the drugs and then disassemble the press so that nobody's got the entire piece of equipment. So all this amendment does is it adds pieces of a pill press to what the leader is doing. With that explanation, I'd be happy to take any questions. Seeing none, we're ready to vote. All those in favor of adopting Amendment Coded 13293 to House Bill 1763, please signify by saying aye.
Aye.
Those opposed, you adopt. Leader Lamberth, we're back on your bill as amended.
Thank you, Mr. Chairman, and thank you for the improvement thereon. I do want to give Chairman Doggett a shout out here. He invited all of us to go tour the TBI lab and facilities not that long ago, and several of us took him up on that invitation. And Chairman, thank you for that invitation. I'd been over to TBI several times, and in fact, have been back to view the expungement unit and see exactly what they do. Something I would encourage everyone to do, based on the last bill that I just had. But as we were touring on Chairman Doggett's tour, I asked a question, and we all kind of asked a question of why is there such an increase in opioid overdoses and so many fake pills out there in the street? And their immediate answer was, well, you can order a pill press on, line. You can just go on the internet and order one of these, and then anybody can mix up whatever substance they want to and just press out pills that look exactly like what someone would buy, at the pharmacy. So that concerned me, and I began talking to some of our fellow members on this committee and members of law enforcement, and that's what spurred this particular piece of legislation.
Leader Lamberth, I want to thank you for bringing this. This morning as I was riding in, I was reminded by another news story on the radio. Now, fentanyl is the #1 cause of death of folks between the age of 18 and 55. Not COVID-19, not violent gun deaths, not car accidents, not heart disease, not cancer, fentanyl. And not only is that a tragedy for our just what it says about where we are as a country, but think about the loss of productivity, loss of life. All of those folks are in their prime earning years, their prime working years. That's when folks are supposed to be raising their kids, going to work in the morning, and living out really the best years of their lives. And the #1 cause of death for those folks is fentanyl. So I just want to take the time to sort of mark that solemn point. And thank you for doing what you can to combat that. So any questions for the sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 1763 as amended to calendar and rules, please signify by saying aye.
Aye.
Those opposed? Oops. Your bill passes to calendar and rules. Yes, sir. Members, the final bill on the calendar is House Bill 1449, which is by me, so I will pass the gavel down to our Vice Chairman.
Thank you, Mr. Chairman. We are now on House Bill 1449. I have a motion and a second, and there's also an amendment that's going on to this. So, motion, second. It is Amendment 011968. Leader, you are recognized.
Thank you, sir. Yes, it is Amendment Code of 11968. It does make the bill. Members, I want to kind of bring everybody up to speed with what we're doing here. A couple of years ago, we reformed together the drug-free zone statute in Tennessee, and we wanted to make sure that we were able to stiffen penalties on those who are truly trafficking drugs, especially to children, but at the same time make sure that there was discretion for the judge inside that zone if somebody was truly in the wrong place at the wrong time. We had judges at that time that came and testified to say, we knew this defendant was truly at their own home with a user amount, but because the Tennessee Code tied our hands, it forced us into that mandatory minimum prison sentence. And so you had folks for relatively low-level drug crimes spending sentences longer than that, and murderers and rapists in our Tennessee prisons. That is not the case of everyone who was convicted under the drug-free zone statute, and I'll be the first one to say that. Those cases were a minority of cases, but they are there. And again, that coming from our judicial community, don't have to take my word for it. But what we have now that we've reformed that law is we have about 495 people who were sentenced under the old statute who are in prison. And I will be the first one again to say that most of those folks, they have a variety of other charges, and they are going to be in prison for a long period of time regardless of this drug-free zone rewrite. However, there are some of those, there are about 50 of those to be exact, who are first-time nonviolent offenders. And so because of this, we wanted to find a judicial solution where these cases could be looked at. Again, I'm a proponent of criminal justice reform, but I am not a proponent of treating everybody with the same brush, of just, saying, okay, this bucket of people must be fine, we're going to do something different now. These folks need to be evaluated on a case-by-case basis. I would say, even if you look at the First Step Act, which former President Trump championed through the Congress a couple of years ago, that process passed by that president is also on a case-by-case basis. So they're looking at those cases to see if those folks should qualify for any relief. So under this bill, what we're doing is we're giving an opportunity for folks who were convicted under the old statute to file a motion and go before a judge in consultation with the district attorney and to have a hearing on this motion, whether or not they should be able to seek relief based on the new sentencing statute of that drug-free zone violation. There's a couple of very important things here that I want to point out. Number one, the court is able to consider the defendant's criminal record, including any subsequent criminal convictions. They're able to consider the defendant's behavior while they're incarcerated, so they're able to see if they've been truly trying to reform themselves or not. The circumstances surrounding the offense, including but not limited to whether the conviction was entered into pursuant to a plea deal. And I think this is really important because as we spoke with members of law enforcement, what we learned was that there were some of these folks who had a variety of other crimes at the time, but maybe they were gang-related, for example. And they didn't want a family to have to come forward and testify because they said, look, if I testify against this person, they're going to seek retribution against us. And so the prosecutor, using their prosecutorial discretion, could say, well, we've got them on a drug-free zone charge, and they're going to be going away for a long time based on that, so we don't have to expose your family to danger. So we wanted the judge to be able to see that information to make sure that we weren't putting family members, innocent Tennesseans, at harm. Also, if a previous motion was made under this section to reduce the sentence and it was denied after review, they cannot do that. So we don't want to create this unending cycle of appeals. Again, we're talking about a defined population. It's never going to get any bigger because we've already changed the sentencing statute. We've got an encapsulated number of folks, and then I believe we have a very small percentage of people in that bucket who would be worthy of this relief, but we've got to get a judge and a DA with their hands on that file to look at that case to see whether or not they qualify. Another important thing I would point out is that if they're petitioning for relief, but that this would not change their overall circumstances, so let's say they have another conviction that's got them in prison, say, for life, and they just also happen to have a drug-free zone charge, they're not eligible to have a hearing under this bill because, again, we're just clogging up the court's time for no good reason. They're not getting out anyway. So that's the substance of this amendment. Again, I've worked very hard with members of law enforcement to make sure we get to a place to where we believe we're doing no harm and that we're trying to get those folks who were convicted under that old sentence at least an opportunity to have that file opened and examined. If there's somebody who's truly worthy of relief under this, then we want to make sure that they get it. But we've also tried to make this very, very a high bar to jump through to make sure that we're not letting anybody out who doesn't need to be out. So with that, I'd be happy to answer any questions.
Thank you, Chairman Curcio. And I would just like to say that based on what I know about this bill, I do appreciate the bill itself. And I think you said you're trying to create a way to look at these. And that doesn't give anyone a pass. It just says that if someone maybe deserves a second chance for a small crime, then there should be a way. And so I appreciate that. And I wonder, is there any questions on the amendment? If not, we're voting on Amendment 11968. All in favor, say aye.
Aye.
Opposers, no. The ayes have it. Now we're back on the bill 1449 as amended. Chairman Curcio.
Thank you, Mr. Chairman. The amendment makes the bill.
Question's been called. If no one is in objection, we're voting on House Bill 1449 by Chairman Curcio. All in favor say aye.
Aye.
Opposers, no. The ayes have it, and it's going on to Finance.
Thank you, Mr. Chairman, and thank you, committee. Members, that exhausts our calendar for today. Chairman Hawk, you are recognized.
Thank you so much. For a personal order, if I could, we've got a few minutes extra in this committee, and I was intrigued by the names on the first bill on our calendar, House Bill, item number 1, House Bill 1646 by Representative Hall, was also Senate Bill 2013 by Senator Bell. And I'm wondering if legal staff may be able to delve in, if you've got some free time, what would have happened if this was the first year of a General Assembly? Representative Hall passes the bill in the House, then he gets elected to the Senate and he takes over the Senate legislation. Is that, and again, you may not have an answer at the moment, but sometimes my mind goes to interesting places like that, and just wonder if there is precedent for a House member passing a bill and then devolving into a senator and then passing the same bill in the Senate or vice versa. So just food for thought there.
Chairman Hawk, I believe in that case he would be an ineligible receiver. Personal foul, yeah, I think that's right, 5-yard penalty. Any other questions for legal? Seeing none, we're adjourned.